I think Barton is incredibly important for all of your listeners because although you might think that this is a technical issue in removal defense and the only people who need to understand this case are people who do removal defense, it's in fact extremely important for anybody who's filing any application with USCIS, including an application to change your status, adjust your status, or seek naturalization, because any contact with USCIS has the potential to put somebody in removal proceedings because the grounds of potential removability are vast.
Yeah.
And they're in a sense designed to be vast. And the safety valve for being subject to removal has always been that you can seek cancellation of removal, or I should say it's always been since 1996. Before 1996, there was a form of relief called 212C relief for permanent residents and a more generous form of suspension of deportation for people who were not permanent residents. So Barton is huge in terms of closing off access to relief in a removal hearing if a client happens to wind up in removal, which could happen for anybody. Anybody could wind up in removal. And what Barton says is that the requirements for cancellation of removal, which, so for permanent residents, those requirements are permanent residency for 5 years, continuous legal presence for 7 years, and no aggravated felony conviction. So in those requirements are, what the Barton case does is it takes the part of that, which is continuous legal residence of 7 years, and creates a new bar by the way it interprets conditions that can stop continuous residence. So this sounds super, super technical, but the reason it matters is a lot of people begin their legal residency in the United States when they're, 12, 13 years old, 14 years old, whatever, and incur some relatively minor criminal problem when they're 18 or 19 or whatever. It could be violating a marijuana law. It could be, a petty theft. It could be a turnstile jump. It could be all kinds of things. And what this decision says is that those things that happen in the first 7 years have huge importance down the line. It doesn't matter if the person's put in removal proceedings 4 decades after coming here. Mm-hmm. The clock for cancellation of removal can stop in those first 7 years for reasons that would not have even made the person deportable. And that's what the decision does. It is enormous. Mm-hmm. And probably the best example of how enormous it is drug offenses, because drug offenses for inadmissibility, anybody who practices immigration law knows that for inadmissibility, it's any violation of a regulation or statute here or abroad, which is either an admission, which is a technical term. There are certain things that are required for somebody to admit to a crime, or a conviction is a bar to admissibility. Whereas is a ground of inadmissibility, I should say, and you might seek a waiver or whatever, but it's a ground of inadmissibility. Whereas for deportability, Congress very intentionally in the 80s put in exceptions, and one of the exceptions is that if you have a first offense, meaning conviction of possession of marijuana of less than 30 grams, that's not a ground of deportability. And generally, deportability requires a conviction. It doesn't just require conduct and an admission. Mm-hmm. So what Barton does is it allows the inadmissibility grounds, which are really broad and could be lots of people who've gone on to have exemplary lives. It allows those things that happened in the early years to cut off access to a relief hearing. So it's a horrible, horrible decision. And, just in terms of the result and what it means for immigration practice and what the threat is to the millions of people in the United States who are permanent residents. It's also a threat to people who are not permanent residents, who might be seeking non-LPR cancellation. So it's a threat to all of those people, but it is most shocking. It's most shocking in its effect on permanent residents because of the long history of immigration law, which has been, you know, has not been easy on permanent residents, but has made sure through decades and decades of history that there is an available method of relief before an immigration court.